Was the price of the dog in excess of $200? What kind of dog was it, young lady?
A Yorkie.
I thought you said a dog.
A Yorkie.
I know, I heard what she said. Oh, it was a Yorkie?
A puppy.
Yeah, but that's like this big.
Yeah.
How big is a Yorkie? What do I have about a Yorkie? That's not a real dog. I like big dogs. I had Yorkies, but I lost them because they're so little. They just ran off. I can't find them. That's why I get big dogs. I'm sorry. All right. Why'd you do that, young lady? Wanted a dog.
I did for my daughter.
How old's your daughter?
She's 2. She'll be 3 on May 23rd. Someone recently before that stole.
Pardon?
Someone recently before that stole my daughter's Yorkie.
All right.
Well, when you make
Anything else?
if it's on the record, it's reported. So
I'll wait for
talk
the
about the cases.
officers to testify about.
Yeah, yeah.
I have concerns about flight risk and ability to remain law abiding while out.
Jew. Motion for bond reductions denied. Bond will continue. Thank you.
Talk to your daughter, okay?
Yep.
Donovan Buckner.
I'm here, Your Honor.
Hey.
And Assistant Public.
No, talk to me.
Here,
Just
on behalf of Mr. Buckner. Mr. Buckner, could you state your name for the record, please?
Donovan Buckner.
thank you, sir.
Your Honor, we're asking for an adjournment in this matter. We have not been able to make contact with Mr. Buckner. We did send him an email, but we have not heard back from him. So I'd ask that the court have him contact our office.
All right, Mr. Buckner,
Yes, sir.
contact the public defender's office.
Yes, sir, I will.
All right, do you have their phone number?
I believe it is in the email that is was sent to me. I will go through it and call them.
You're outside.
Okay, call them. And make sure to return their emails.
I will make sure to be on it, sir.
June 4th, 2026, 9/8, bond continued. Court calls the case, People versus Stephen Hamel. Mile.
Assistant Public Defender Chinazi Kiriak Rulu, Your Honor, on behalf of Mr. Stephen Hamil, Judge.
Sir, sir, other than in her ear, state your name, please, for the record.
My name's Stephen Herman.
Thank you.
I'm sorry, Judge.
No, that was good.
Your Honor, we are in negotiations with the people. We're asking for an adjournment in this matter. And we'd like to address bond as well.
Probable cause conference, I'll go to May 28th, 2026. 9 a.m. Yes.
In regards to bond, Your Honor, Mr. Hamil reports to us that he is gainfully employed. He is the sole, well, his significant other is currently pregnant, Your Honor, and he is taking care of her as well as 4 children. 5 children in total, Your Honor. He understands the severity of these charges. However, he is asking that the court allow him to be released so that he can continue working and financially caring for his family. He is okay with the tether. He lives locally, Judge. I know that the bond at this point is just too much for him to pay. He's not even asked for a PR bond. But if the court could at least reduce the bonds slightly, he would be able to rally together some other family members to assist him financially to post that bond. However, where it is right now, he states that there are a number of things that he needs to be doing for his family and the condition of his significant other. The pregnancy is I don't know if it's considered as high risk, but he states that she's really been having a difficult time. So taking care of the other children have been difficult for her, and that was where he came in.
Response.
Object to a bond modification at this time. I believe this incident involves him showing up at an apartment, carrying and looking for his other children. We initially requested a high cash bond with no 10%. And yeah, we would set up applications.
And just very briefly, Your Honor, I have to note that the report does not indicate that he made any threats to anyone with this particular gun, nor did he point it at anyone. It's just the report says that he went to an address and was asking for his children. Obviously, we won't get into details.
Were his children armed?
Yes.
Allegedly.
Allegedly, I like that. Yep,
And he allegedly is a person who cannot possess a firearm.
that is correct, Your Honor.
Motion for round reduction denied. Bond will continue. Thank you.
I have 20 minutes and come back.
Clerk calls the case People versus Aaron Burrows.
Ready to go for the hearing?
Ready, Judge. Marshal Peace with Assistant Public Defender on behalf of Aaron Burrows, who I am hoping is present somewhere in the courtroom.
I think Bishop knows.
Bishop has the answer? Oh,
Okay, go ahead.
I was hoping.
How do you mind?
Your Honor, we have reached out to Burrows. We thought that he would be here, but apparently he is not. For the record, we would request an adjournment, but do not know why they are not present.
Bench warrant will issue for defendant. Your bond will be -10,000 cash shares. Court does call the case versus Shantia Holloway. This is-
Good morning, Your Honor. Joy, Assistant Public Defender, and on behalf of Ms. Holloway. Holloway, would you please state your name for the record?
Shantia Janaya Holloway.
Your Honor, Ms. Holloway is here for a bond violation. We've had an opportunity to go over the report together. And she has been in custody since last Thursday, so for for 7 days. We are requesting at this time, she is at this time wishing to admit to the violation, that she was unaware that the no contact order of the limited nature of the exclusion zone for the no contact order. She had spoken to her
Go ahead.
spoken to her child's father, who was in need of Pampers and wipes, and they had agreed, instead of her coming there, for her to drop off those items at a friend/neighbor's home in that same area. But on the opposite side, she indicates that when they're was driving around, that she was going to that person's house, and that that was part of what was necessary for her to leave. She understands and is very clear that she does not have a criminal history like this.
The zone.
I did, sir.
And she did. It was not as quickly as they would like. She was trying to explain that she was trying to get the diapers and such, and that she was not trying to go over to the house. But I think now she has not had this kind of trouble or been incarcerated on a case for the number of days that she has on this case. And she's really learning her lesson, and this will not happen again. So we are asking that.
Police were also kind of suspicious as to whether or not she had been drinking.
She indicates that she has, I do not know why they, go ahead. Sir.
May I speak, Your Honor?
But you can.
Go ahead.
So when the officers came to my godparents' house to get me, they said that it was the tether company that wanted to pick me up. I was on hold with the non-emergency line trying to get a civil standby, but he didn't let me explain that. And it's like when you come inside my apartment complex, the only way that you can exit out is if you have to go all the way down and then come around the opposite side, because it's like gates that they have to let up. I understand the seriousness of the situation, and I am very sorry, Your Honor, but my child really did need those Pampers and wipes. But I still have not had no contact with my kids. I have been blowing, doing my sober link. I have been sober, and then the officer that arrested me, she said that me taking a PB wouldn't hurt or harm me. She just said that if it was up to me, and she didn't say that it was mandatory. So that's why I was like, well, I've already had a signed sober link. Why do I need to take a PB when I did use my sober link that day, and it was a compliance test? That this would not happen again, Your Honor.
And for some additional information, the child who is the subject of the case still continues to reside in Pontiac and was not in any, this was for her youngest child who is with his father.
With her father.
I'm sorry, with her father.
Response from the people.
I obviously read the report. Doesn't seem like it was vindictive or anything on the defendant's part. But what's disappointing that it was within hours of us discussing it and discussing how her and counsel needed to go about for taking access to her younger child. So while the actual context of what she says she was doing and what I tend to believe she was doing is not negative or violent or like that. I just have concerns that kind of disregarded what we talked about kind of ad nauseum last time that we were here. And I have concerns that when asked by these to issue refuse, but I don't have a lot of information from the police as to why they requested that she do that. That's a long-winded way of saying that I'm ultimately going to leave it up to you. I think that she needs to continue to maintain her sobriety, but that she needs to also continue to follow the court's orders in terms of where she can and cannot be. And so I'm not going to be that she can see her children at this point in any capacity if she is to be released.
And my own client, if you were to change
Well,
the
was
link.
she going to,
I'm sorry.
where was she supposedly going to take these diapers?
To a friend's place who lives in the same apartment complex.
But
it's the one off Grove Lakeshore. So it's a huge apartment complex. So she did not think that taking it to that other person's place so that her partner could pick up the diapers and wipes would be an issue. And she knows now very clearly that that's an issue. She's nodding her head in agreement, and she
When the
And
police
Miss-
showed up, you were upstairs, right?
She was at a different location, that's, I
Oh,
believe at
I
that time.
did leave, Your Honor. It was a quick, it was really quick after I left the apartment complex and I went to my godparents' house. Tell me to leave, so I went and parked my car. And then the police showed up shortly after that. I was not upstairs when they came. I asked them, was I able to change my clothes? And they did let me change my clothes because I had on something prior to when I was at court. It was a dress.
If you look, you'll see that in the report, it gives another address. And it's my understanding that address is not within the complex. And that was where the tether agent or the tether agencies dispatched. And that is not in the complex. It's, as she said, at her godparents' house.
You were in the zone. Why were you arguing with them?
Officer, I mean, sir, I'm sorry. Oh, I wasn't trying. I was just trying to explain to him like what I was doing. And when he called me, I was on hold with the non-emergency line. Because I've had to get two civil standbys and then the other tether people, they let me.
When they told you you were in the zone, why didn't you just leave
So
instead of arguing with them?
I should have, Your Honor, and I'm very sorry for that. I'm telling you, Your Honor, this would not happen again.
It shouldn't have happened this time.
I understand.
Young lady, when you left here, I know you were not happy with what the court said that you were going to get a scram tether before you saw your kids. I know you weren't because of the way that you walked out. And you have to understand how you look because some people think I'm not paying attention to what's going on. I'm paying attention to everything that's happening in this courtroom. And I saw you stomp out past the gentleman the gentleman and the woman that were here for supporting you. You just walked past them. You walked out, and then within hours of that hearing, and we had talked about, and I think it's important to point out, we had talked about how you were going to go about getting visitation with your child. You weren't happy with there was going to be a scram tether prior to that ever occurring. You walk out of here, and then next thing I know, you're in the zone, the exclusion zone. And then when I get the entirety of what I have here, people are, could be an accident, could have driven through it. But then when I get the entirety of the report, you're arguing with the people. You're arguing with them when they're telling you you're in the zone and to leave. And you don't leave. And then I think there's a reason why I don't understand why all of a sudden then all of this happens. Understand some of the underlying charges in this case. They ask you to take a PBT and you don't.
Am I able to?
I'm not saying that you could be compelled to do it. You didn't have to. Right. But if you look at what is here, I don't get why you didn't.
I think in retrospect, Your Honor, she would. I think, but she indicated at the time she was in compliance with the sober link and had blown in earlier that day,
Yes.
and so
I already did my sober leave that day, Your Honor. And I explained that to her. I just didn't bring it with me when they arrested me, like my sober link that I had.
so this has been a very harsh lesson, but she has learned it.
Oh, harsh, yeah.
Of her own
May I
making.
speak, Your Honor? So I'm not opposed to the scram tether if I will prove to the court.
Oh, so, yeah, now you want the scram tether because you want out. You messed up big time. Because I'll be honest with you, when I heard the allegations, I don't know why you're out. But I figured somebody saw something that you were in compliance and maybe there'd be some. And then you do this. So young lady, you tell me why I should trust
Your Honor, I feel like that I should be trusted because, well, for one, I am starting the peer recovery program. I missed my treatment in the program Monday because I was incarcerated. I have to go on the scram tether and go back on GPS tether. I would not enter the exclusion zones anymore, ever. Because this is my first time being in trouble. Like I have not been in trouble or have to go through like things like this before. I also have a job that I have to get back to as well. It's a really hard lesson for me, but I really feel like sitting in here, even on Mother's Day weekend, like I really have learned my lesson. And if you trust me, I will not disappoint, and I can prove to the court that I can stay sober and stay compliant. And I just ask that you would please take that into consideration, Your Honor.
what are we doing with? The case is already set for what? Prelim before me
Yes, Your Honor.
Your Honor.
this Tuesday.
About this. On Monday, there is a interview, a child access center interview scheduled with a child victim on this case. So I don't think I'm going to have the protective order signed, that interview over to prior to that preliminary exam. I just wanted to put that on the record so that that's clear.
We understand that. At this time, we'd like to keep the date and then, but understand
Right.
maybe there may be some additional, if Your Honor would allow discussion on that day. I know Ms. Yagi plans to keep this case and to be at the preliminary exam. It's going to ultimately be her case.
Previous editions is reinstated. Young lady, I'm gonna give you a fair warning. Because this case is before me. You mess up at all, I will put you back and you will stay. Am I clear? With the previous conditions, including the GPS, she will also get something else for her other leg. I want her on a scram tether.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case, People versus Sean Call.
Plug Fender down. Libo form, Mr. Call. Mr. Call, could you tell the court your name, sir?
Sean Call.
And take your
Thank
name out of your. Interim requesting adjourn. We did get an offer. I think we're likely to accept it, but I guess I give Mr. Call some time to think about it.
May 28th, 2026, 9 a.m. Bonds continued.
Thank you.
Court calls the case, People versus Amanda James.
Go to the same thing, Your Honor.
Assistant Plug Fender down. Libo form, Ms. James. Ms. James, can you tell the court your name, please?
Amanda James.
Thank you.
Interim requesting adjournment in this matter. We're still negotiating. I would also like to address bond, please.
Okay. I'll adjourn it to May 28th, 2026.
Thank you, Your Honor.
And as to bond,
Sorry.
Did you still want me to address bond?
Yeah,
I'm
just tired.
Your Honor, Ms. James would admit to her failure to test. What she's explained to me is that her failure to test resulted of her being overwhelmed and confused between this case and a 1482 matter. She explained that she'd been in contact with the 1482 court regarding a warrant recall, which she believed would apply to this case as well. She's also indicated that she has some cognitive and memory challenges, a history of past injuries. We'd ask the court to consider a personal bond or in the alternative, a $2,000 10% bond that she indicates to me that she could post. She will test as recorded for release. We have no objection to a tether. She does have a part-time job as a home care assistant. She is concerned that she will lose that job if she's unable to get out. She's also concerned that she'll lose her housing if she's unable to pay her utilities.
Respond.
Your Honor, people have some concerns because we believe that this defendant had been bond for 6 months following failure to appear. Believe this is also set for bond or a violation hearing, if I'm not.
Yes, it is.
But also be that it breaks this budget, but if the request modified bond, you would be able to this.
Anything else, Mr. Olivo?
I would just note that we would not object to that tether request.
I don't understand why you're saying you got mixed up with another order?
Yes, Your Honor. There was a case prior to the case I was in for, the 20, what was it, the 24 case?
Okay, so where have you been?
I've been home and working. Like this, me coming in this time, someone else was I was at a friend's house, a situation occurred, and I gave my name to come in. So I haven't
Failed to appear.
and I did a warrant recall. I'm sorry, I didn't mean to cut you off, but I did it for the wrong case. I wasn't even aware, but I apologize.
So why didn't you, but you've been gone for quite a number of months.
I wasn't aware that this case was this 25 was. See, that's the thing. I wasn't aware this case was an active going case. I knew it was pending,
What do you mean it?
but I didn't. That was the confusion.
Your Honor, I think Ms. James may have believed that there was a pending warrant recall request. Is that what you're indicating, Ms. James?
I did it for the wrong case. I was waiting on information. It doesn't make sense when I.
So you're saying that you knew you were supposed to be here on this case, did a warrant recall, but it was for the wrong case, and did nothing.
I knew I had a warrant. I wasn't confirmed on which case. I thought it was.
Well, how'd you come into custody on this case?
I just came in because I had a warrant. I just wanted to clear my warrant.
So you
And
didn't
they told
before you had a warrant?
Not for this case, no.
So how'd you find out you had a warrant for this case?
When I came in, they told me I had the FOC and I had the 0932 case. And then they said, and you had a bond violation for 20.
When you're saying they told
The officers,
who?
the officers, when they detained me. When I was in the police car, they're like, oh, you have this case. Oh, you have this case.
Okay, so why were you in the police car?
Because where I was at a friend's house
Okay.
for being taken for a warrant. And they asked my name. I gave my name because I knew I had a warrant. And I came in on the.
But I thought
Go ahead.
yeah, it was all clear.
Can you explain it?
Your Honor, I think what Ms. James is attempting to explain is that she was brought in on this warrant when she was visiting with a friend. The police came to arrest a friend.
Without doing everything else but taking care of this warrant. Okay. Motion. Found looking. Thank
Thank
you.
you, Your Honor.
Courthouse case, People versus Castilian, Patton Roberson.
And on behalf of the people you're on.
And assistant of the. Mr.
There he is.
Mr. Cotton Robertson,
Sir, can you state your name? That's him. I can't make him out. What are we doing?
Your Honor, we need to be able to reach Mr. Cotton Robertson. Could the court have him call our office? We have a plan that we would like to put into motion, but we just haven't been able to.
I'll adjourn the matter to June 4th, 2026, 9 a.m. Sir, you need to call the public defender's office today. Hear me?
Yeah, I hear you. And the number is, I've been trying to reach out to Nicholas.
Hold on. You need to call, Mr. Cotton Rose, you need to call them today. Make sure you have a good phone number for you and an email.
Okay.
Okay? Because otherwise we're gonna have a problem.
All right.
All right? If you don't touch base with them, your next appearance on the 4th, you need to appear in person. And I'll make sure the two of you are in a room talking.
Yes, sir.
All right?
And Mr. Robertson, it may not be Nicholas who is handling your case. That's why you have to call the office and not just him, because if it's assigned to someone else, we need to be able to contact.
I understand. Can I
Call
say
me and
something?
talk about it.
They said Shanaz is supposed to be reaching out to me like 5 different times. I don't know who that is. I never heard from her. Never got an email. I don't
You
even
know
know
who
that is.
Chinaza is?
No, I don't know who she is at all.
Oh, everybody knows Chinaza. So if Chinaza calls you, you need to answer.
Oh, my phone has a rung from Shanaz. It's rung from 2 different guys, but no female. But I understand.
Okay.
I will call the public defender's office.
Okay,
today.
just call the PD's office.
Yep. You got the number for them?
Sure. Area code 734
2 seconds.
222 6970.
You said 6170.
6970.
All right, I appreciate you.
All right. Take care. We'll see you in a few weeks.
Thank you.
I am shocked. I thought everybody knew Chinaza. Saying. Just be the little world I'm in. Anyway, court calls case, People versus Craig Robinson.
Assistant Public Defender, Chinaza here. I can really, on behalf of Mr. Craig Robinson, who's approaching. I think Mr. Robinson knows who I am, Judge. Come on up. Mr. Robinson, state your name for the record, please.
Robinson.
Thank you.
Your Honor, we respectfully request that this matter be set for preliminary examination.
All right. Discovery is complete.
To our knowledge, Judge.
Do other witnesses available to 26? Preliminary examination will be set May 26, 2026, 9 a.m. before Judge Fresh Hour. Bond continue.
Thank you, Judge.
Court calls the case People versus Enrique Davis. Might be Eric. But yeah, because there's no end. Eric Davis.
Yes, I'm here.
All right.
Senior Assistant Public Defender representing Mr. Davis.
Sir, state your name.
Eric Davis.
Thank you.
At this time, we are asking for a preliminary examination.
Discovery is complete. People have their witnesses available to 26. Preliminary examination will be set in person, May 26, 2026, 9 a.m. before me. All right, sir.
All right, thank you.
Bond continues. Thank you.
Thank you.
Court calls the case of the People versus Jason Szymanski.
Joy Gaines, Senior Assistant Public Defender representing Lansky, who's approaching the podium. Your Honor, there was an offer extended that if Mr. Szymanski waives one, he could plead to one count and another count. The second count would be dismissed. Mr. Szymanski is asking for some additional time to discuss that and think about that offer. We're asking for a briefing.
During this matter out May 28th, 2026, 9 a.m. Thank you.
All right, thank you.
Court calls case People versus Tawan Edison.
Morning, Your Honor. Reading for the people.
Tawan Edison,
Yes. I'm here, Your Honor. Where's Dan?
That's me. Joy Gaines, Senior Assistant Public Defender, representing Mr. Edison.
sir, can you state your name?
Tawan Antonio Edison.
Thank you. What are we doing?
We're requesting a preliminary exam, Your Honor.
Discovery is complete.
That is my understanding.
People have their witnesses available the 26th.
Court, Your Honor.
Preliminary examination will be set May 26, 2026, 9 a.m. before Judge. All right, bond will continue. Thank you.
Thank you.
All right, thank you, Your Honor.
Thank you, sir. Court calls the case, People of the State of Michigan versus Terry Little Andre,
For the people.
or Little Andre Terry.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Terry, who's in lockup.
Your name?
Little Andre Terry.
Thank you. I have before me a plea form indicating that he's going to plead to an added count 3 of retail fraud in the second degree, the 1-year offense. Upon his plea to that charge, counts 1 and 2 would be dismissed. There's sentence agreement of no restitution. That's the court's full understanding of the agreement.
Yes, Your Honor.
That is correct, Your Honor.
May I have him sworn?
Raise your right hands. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so?
Yeah.
State your name, please.
Little Andre Terry.
Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than 2,000, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty?
Yes.
I should also advise you, while I'm taking your plea, I would not be your sentencing judge. You'd be sentenced before Judge Washington in the 14B District Court. You understand that, sir?
Yes.
Okay. So to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right, you signed or had someone sign on your behalf an advice of rights form?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will. And because you believe that you're guilty?
Yeah.
July 26, 2025, at the location of 010 Whitaker Road in Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do at the Kroger store that makes you think that you're guilty?
I took some products and stuff from there, some alcohol and some food from there.
Say again?
I took some food and alcohol from there.
Tried to walk out without paying for it?
Yes.
Store was open to the public at the time? You didn't have anybody's permission to take that property, did you?
Oh,
And was the total value of everything that you took in excess of $200? Yes?
yes.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the people or the court would no longer be obligated or bound by any sentence evaluation or recommendation. You understand that? Counsel, you aware of any other promises, threats, or other inducements which have led to this plea?
No, thank you.
And have I complied with the court rule?
I think the court may have missed asking if the merchandise was for sale, but other than that, I'm satisfied.
I think he said he took it. That's a good point. The stuff that you were taking out was property that Kroger had offered for sale.
Yeah.
I'm satisfied.
Yes, I'm satisfied as well, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
June 25th at 10 a.m.
June 25th, 2026, 10 a.m. before Judge Washington. Bond,
I'm so sorry.
go ahead.
May we address bond, please?
Can I stop you? No, go ahead. I'm just put it that way. Go ahead.
So, because Your Honor, Mr. Terry has some pending matters in 15th that are scheduled for sentencing May 29th. For those, by the time he is there for sentencing, he will have had 72 days in the Washington County Jail. We're asking that he be granted a low cash bond or a personal recognizance bond so that on this case, and this is the last matter that he has to resolve. And at this time it is.
So he's going to 15th at the end of May.
That is correct.
Those are the last things that he has to withdraw. Besides this,
That is correct.
any response from the people?
Judge, I asked that he at least get this probation interview done before he's released. It's not quite a few cases going on, so I'd like to see it evaluated at 14B. For converting to a PR or cash bond.
I'll grant the request for a reduction. I'll continue his bond as it is right now. I will grant him a $1,000 personal recognizance effective May 30th, 2026. So after he takes care of his 15th, this won't be holding him.
Thank you.
All right. Thanks. Court calls case People versus Kaloni Franklin.
Morning, Your Honor, Raymond Cook for the people.
The public defender, United Area on behalf of Kalani Franklin.
They here?
Yes, sir.
Sure.
Oops.
Franklin, state your name for the record. Kalani Franklin.
All right. Have before me a plea form indicating she's going to plead to an added count 2 of retail fraud 2nd degree. The 1-year offense upon her plea to that charge, count 1 would be dismissed. There is an agreement to sentencing under HIDA. That's the court's full understanding.
That's ours.
That's correct.
That's ours as well. Good.
May I have her sworn?
You solemnly affirm the testimony, the whole truth and nothing but the truth, so help you God.
Yes. Kalani Franklin.
Ma'am, it's this court's understanding you're going to plead to an added count to a retail fraud 2nd degree. That is a misdemeanor punishable by up to 1 year incarceration. A $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Okay, yes, Your Honor, I understand.
Okay. Still wish to plead guilty?
Sure.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
The paragraph 5, you'll see a copy on the podium. Those are your rights if are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you are indeed guilty of this offense?
Yes, I do.
Pardon?
Yes.
On the date of December 22nd, 25, at the location of 1254 E Horse Road in Ypsilanti Township, Washington County, State of Michigan, what did you do at Pet City Pets that makes you think that you're guilty?
I took a dog.
Okay. So you went in, you took a dog,
I stole a dog.
store was open to the public at the time?
Yes.
You didn't have anybody's permission to take the dog, did you?
No.
And this dog was offered for sale?
Yes.
Was the price of the dog in excess of $200?
Yes.
Mhm.
500.
What kind of dog was it, young lady?
A Yorkie.
I thought you said a dog.
A Yorkie.
I know, I heard what she said. Oh. It was a Yorkie?
A puppy.
Yeah, but that's like this big.
Yeah.
How big is a Yorkie? What? What do I have about a Yorkie? That's not a real dog. I like big dogs. I had Yorkies, but I lost them because they're so little. They just ran off. I can't find them. That's why I get big dogs. I'm sorry. All right. Why'd you do that, young lady? You wanted a dog.
I did for my daughter.
How old's your daughter?
She's 2. She'll be 3 on May 23rd. Someone recently before that stole,
Pardon?
someone recently before that stole my daughter's Yorkie.
I normally don't do. You guys are going to do something better than this. I'm not going to accept a plea.
Okay.
I'm going to adjourn this out 2 weeks. You guys figure something else out.
Judge.
Probable cause conference, May 28th, 2026, 9 a.m. And I'm just going to let you know that if what she's telling me is correct, I mean, certainly people can do wrong, but I don't know that she should face 1 year incarceration for that. Thank you. We'll see you in a couple of weeks. Bond, continue.
Thank you.
You're welcome. Court calls the case, People versus Ashley Street.
That's all this for the people.
Troy Gaines, Senior Assistant Public Defender representing Ms. Reed. And would you please state your name for the record, ma'am?
Ashley 3.
And just so your honor is aware, she does have her mother here for moral support.
Pardon?
Her mom is here for moral support. This time, we are asking to adjourn the PCC, but to address bond violation. In terms of the bond violation, at this time, my client wishes to vet. She indicates that she did in fact relapse, that and that she has been in custody now since a week ago today. And so we're asking that the court consider taking her and sentencing her to time served for the bond violation. Because, as I don't know if the court is aware or remembers, she had she knew that she had relapsed. She had gone through her insurance to Henry Ford Hospital in Jackson, who at the time was recommending outpatient treatment. She did explain to them that because of the relapse, that she may, in fact, have to be incarcerated. They indicated that they would still be able to have a place for her upon her release, and that if necessary, they could get her into inpatient treatment. Again, this is through her insurance, so we're asking if the court would consider releasing her with credit for the days served, reinstating her bond, placing her, if deemed appropriate, on scram tether, and allowing her to go into treatment through her insurance, and provide, if the court wanted her to provide documentation of that appointment by Wednesday so that she could get that in, to Your Honor, she'd be able to do that. I'm sorry.
I have a couple of concerns. Certainly there's the violation of the bond condition, but just the judgment of having a child blow into the sober line. I don't know, and I understand what you're saying regarding some of that, but that's a messed up judgment. That's the only way I can, messed up being a legal term. I don't even know how you get there.
I think you saw her nodding her head in agreement that that was messed up judgment. There are, I want to be careful with my words just because I'm not sure who all may have access, but there are other extenuating, triggering circumstances in the household as related to her personal relationship.
Okay.
And she that were part of the relapse and the triggering for that. And she is trying to get out of that situation. She has a license in medical billing. She's worked in that field before, actually over 20 years in that field. And she had just started a new job, a better job that she hopes will position her to be out of the situation that is triggering. And they are holding it for her right now. They were aware that she had this case pending.
All right, respond.
Your Honor, last time that we were here, the people expressed their extreme concerns over the defendant's behavior. I understand she's admitting to having a relapse. I'm not sure if she's going to admit having the child blow into the sober lane. I do think it's worth noting, and I would like the court to just have it in its mind that her sober lane flow was a 0.083. So this wasn't as though we had one drink or two drinks. This is drinking, and it's of concern to the people that was the point that we got to. I believe last week we discussed that she had been approved for intensive outpatient, and I don't recall what Ms. Gaines said on the record a few moments ago, and I apologize if it was going to be inpatient or outpatient, but this does, in my non-medical opinion, screen for inpatient. The history of what I've seen, the concern of the people is I don't know much about the Henry Ford thing, and I would like to learn more before I make the agreements. So at this point, I'm not agreeing to the request for release to treatment, but I will leave it in the court's discretion. And I hope that the court will address any further questions it has of me or anything else. Those.
And I know that my client wishes to speak so that you can hear from her. I did just want to clarify my words that I'm focusing on the relapse because there would not have been any engagement of the child absent that is the whole, that the alcohol issue is the whole issue. And by relapse, I was not at all saying that she had had one beer. That is not what she had had half a glass of wine. I was not trying to imply that by using that word.
And then people don't think that Ms. Gates is trying to mention.
So
I was.
No,
yeah. So she's and she is not minimizing that. She is a single parent. And she has not been in any trouble for 12 years. So she is really hoping to turn this around so she can get back on the track she was before being in this relationship that has triggered all of these, the relapse.
what do you want to tell me, ma'am?
I just want to apologize to you and your court. I'm sorry that I disrespected and embarrassed you. I probably don't deserve a second chance. But I need to prove not only to you and the court, my family, my kids, but myself. I was clean for 9.5 years. This domestic violence case in this relationship, I was diagnosed with borderline personality disorder. I don't know if you know, but it's been a struggle. And I've really focused on that. And I knew as soon as I got triggered by him again, I ran to get help. And I just hope you give me a second chance to prove to you that this is not me. Outside of here, Judge, I coach my kid's middle school softball team. She's in travel ball. She's in travel volleyball. I volunteer at her school. I'm supposed to go on a Mackinac Island trip on the bus with her 8th grade class. Like, I'm not a bad person. It's some messed up choices lately. Drugs are not the answer, and I know that. I was clean for 9.5 years. Sorry, I didn't mean to speak. I'm sorry.
I'll adjourn our probable cause to June 4th, 2026, 9 a.m. Defendant having admitted to the violation, I'm going to sentence the defendant to 10 days, credit 8. Defendant is to serve that balance of those 2 days. Prior to her release, defendant must be placed on a scram tether prior to. Then her bond previously will be.
Thank you.
Thank you, Your Honor.
June 4th,
Yes. Court calls case People versus Corey Folk.
For the judge, court shall cease to assist in public defender on behalf of Mr. Falk, who is approaching the podium. Mr. Falk, please state your name for the record. Thank you, Judge. Just speak to Mr. Falk. We are working to find a resolution on this case. We just need a brief adjournment and try to get this wrapped up.
Oh, really? Yeah, come on. Reflect. Run a bench conference in this case. The discovery is complete. The people, if they're going to have their witnesses, would be available on the 26th. Court's going to set this matter for preliminary examination. May 26th, 2026, 9 a.m. That's before me. Bond will continue.
Okay. Thank you, Judge.
Thank you. Court calls case People versus Kyle Zimmerman.
Again, Judge, court shall cease to assist in public defender on behalf of Mr. Kyle Zimmerman, who I'm hoping to hear someone. Oh, here we go.
Oh, this person here.
Please state your name for the record.
Kyle Zimmerman. All right.
Judge, I did tender a mitigation report, Miss Lonnie Felton, and we asked for a brief adjournment for her to review it so we can try and get this matter resolved.
May 28th, 2026, 9 a.m. Bond continue.
That's it.
All right,
That's it.
thank you.
What's the date?
Court calls the case People versus Stephen Javon.
Morning, Your Honor.
Stephanie Cannon on behalf of Mr. Given, Your Honor. And
And because of you, he's refusing.
yeah, no, I was going to tell the court that, yes, because of me, he is refused. I'm just asking for an adjournment. It's my understanding as of yet he is not competent. Last time I checked, last report we had says he is not competent at this time.
So I'll adjourn the competency hearing to, well, we won't get another report now. This is adjourned to June 25th,
Thank you so much, Your Honor.
2026, 9 a.m. Court calls case People versus Jordan Harris.
Definitely, Your Honor.
Right here, Your Honor.
Stephanie Cannon on behalf of Jordan Harris, who is appearing by Zoom.
Yes.
Ms. Harris, could you state your name for the record, please?
Jordan Harris.
Thank you.
Your Honor, we're asking that this case be set for preliminary,
Discovery is complete.
to my knowledge.
We'll have their witnesses available to 26.
Your best, Your Honor.
Preliminary examination will be set for May 26, 2026, 9 a.m. before Judge Freshour. Bond will continue.
Thank you so much, Your Honor.
The court calls case People versus Robert Harris.
That's about Mr. Pico.
System defender on behalf of Mr. Robert Harris, who is approaching the podium. Please state your name for the record, sir.
Robert Harris.
Thank you, Judge. I have spoken to Mr. Fellinger on this file. Sounds like he's working on a resolution that includes something at circuit court. If we could adjourn that for 2 weeks, I think he'll hopefully have an answer from the prosecutor at circuit court and get this matter resolved.
During this matter without objection, May 28, 2026, 9 a.m. Bond continued.
Thank you. All right, Mr. Harris. 2 weeks.
Court calls case People versus Daniel Heelan.
Judge Torshow, both defender has Mr. Heelan, who's appearing by Zoom. Mr. Heelan, would you
Mr.
and state your name for the record once you're unmuted, please?
Why is hearing via Zoom?
Looks like he has
Yeah.
permission, basically, dots on the docket, Judge.
Where was revoked
Okay. Well,
because he had a violation.
okay, I apologize. I was unaware of the revocation.
Local.
I believe so, Judge. I think I can explain the violation also if the court would allow.
Well, I want him here. Then maybe I'll listen to it.
Okay, Judge.
Here this afternoon.
He's indigent, Your Honor. I don't know if he
Pardon?
indigent. I don't know if he has resources to be able to get here this afternoon. I'd have to ask if he could appear. My understanding is he was just released about a month ago from Bear River for a 90-day program. And now he's doing
I'm
out.
gonna adjourn the probable cause conference to next week. To the 21st.
We'll need you here in person then, Mr. Heelan.
Yes, sir.
To May 21st, 2026, 9 a.m. in person.
Thank you, Judge.
Bond at this time will continue. Thank you. Court calls cases of the People versus Douglas Hill.
Stephanie Cannon on behalf of Mr. Hill. Mr. Hill, could you please state your name for the record?
Douglas Hill. You're requesting an adjournment.
Yes, Your Honor.
Matters are adjourned to June 4th, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Versus Eric Jackson.
Ashley Feltus for the people.
Oh, right. Ready, Judge. Court shall feast your assistant public defender on behalf of Mr. Jackson. Please state your name for the record.
Eric Jackson. Sorry.
Bro, that we are requesting a 2-week adjournment in this file. It sounds like Mr. Jackson spoke to our interns and asking me to do a mitigation letter for the prosecutor office. So 2 or 3 weeks, please.
May 28th, 2026, 9 a.m.
Thank you.
Court calls case People versus Brendan Lathrop. No. Even more so, no. I don't know that.
Officer of the court, Judge.
Yes, Your Honor. Mr. Lathrop works 2 jobs, is that right? And he go out in the hallway, he tired and he did not want to disrupt people around him. So he is.
Your name?
Brendan Lathrop.
All right, what are we doing?
Your Honor, we are requesting an adjournment. We are an ongoing negotiation and not too long before Lathrop's case was called, received some additional information from the prosecutor.
4th, 2026, 9 a.m. Bond continued. Thank you.
Sure.
Thank you.
Court calls case People versus Caleb Martin.
Bring for the people.
Stephanie Can on behalf of Mr. Martin.
That was a stall.
I didn't see him. Your Honor, we're just asking for this case to be set for preliminary exam.
Discovery is complete.
To the best of my knowledge.
People have their witnesses available at 26. Preliminary examination, May 26, 2026, 9 a.m. before me. Bond continued. Thank you. Court calls case People versus Eric Mayfield.
Thank you. Appreciate it. Appreciate it.
Is my
Who?
Mr. Feast.
Ready, Judge. Court shall feast your assistant public defender on behalf of Mr. Mayfield. Mr.
Mayfield, state your name, please.
Eric Mayfield.
Thanks.
I will prepare a grant sheet on this one, Judge. It looks like we do have an offer on this matter to resolve it. We just need 1 or 2 weeks to get the paperwork completed.
June 4th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you, Mr. Mayfield. Court calls case People versus Desmond McCaster.
People.
Cannon.
Stephanie Cannon on behalf of Mr. McCaster.
Your name, sir?
Desmond McCaster.
Thank you. Where are you going now?
We're just asking for a brief adjournment in this matter. And I want to run it past the prosecutor to see if that will work with them.
Boy. I don't know what that meant, but good luck to everybody. June 4th, 2026, 9 a.m. Bond continued.
June 4th. Thank you, Your Honor.
Thank you, sir. Thank you. Court calls the case People versus Don Mitchell.
Ms. Mitchell. Ms. Mitchell, state your name for the record.
Dawn Marie Mitchell.
Thank you.
You're welcome. Thank you, Your Honor. Good morning.
I apologize.
Come on. And competent in this case. What were we trying to do on this case?
Well, Your Honor, obviously I haven't heard the jail calls, but Ms. Mitchell did want to set this matter for preliminary examination. But we can wait.
She wants it set for prelim?
Yeah, but we can wait until we receive the jail calls if that's easier, Your Honor.
All right. Mr. Mitchell, I've got to try to make a decision here. Either I'm going to revoke the contact between you and the alleged victim in this case or not. And I'll explain why.
Okay.
Because at least the first taste of the phone conversations that are there can be read to be an attempt by you and the victim to manipulate this process.
It wasn't even about that.
Well,
Listen,
I'm going to suggest that you don't say anything because that's the way it certainly could appear based upon that,
Thank you.
which you should have realized could lead to additional charges for you. So I'm going to suggest that you and the alleged victim in this case, I'm not going to remove the no contact. I should, but I'm not going to because it was given by the magistrate. But I'm going to suggest to you that you don't talk about it anymore because you're going to end up in greater trouble than what you got now.
so don't talk about the case. You understand that?
Yeah,
Okay.
I got my word. Got my word. Thank you, Your Honor.
I'll adjourn it out to the June 4th, 2026 at 9 a.m. Bond at this time will continue with that admonition to
All right. God bless. Have a good day.
you.
Wait in the hallway out.
And I'll talk to somebody about that.
Should have.
Court does call the case, People versus Maurice Robinson.
And Assistant Public Defender, can I be carried out to Your Honor, on behalf of Mr. Maurice Robinson, but not with. Judge, we were informed that Mr. Robinson was released from our jail, and I believe he was picked up by Winnebago County. That's in Illinois.
I know that.
So I did not.
Try to say Winnebago County here.
Is there one here?
No.
Okay.
She just saw an RV and she said, "Oh, that's a county up there." Go ahead.
I did. I thought it was up north, Judge. I don't know where that is. So we've informed the people, so they're gonna work on getting a writ to have him here, but we have not had contact with him. That's just all we've been able to.
But do we know he's in Winnebago County?
I believe so. I know.
That's really a no.
From a PD who was representing him on another case, and that's what she stated that she found out.
This courtroom instantly turned awkward and hilarious after the judge started questioning a woman about stealing a dog. But the moment she admitted the dog was a tiny Yorkie, the entire courtroom mood changed. The judge looked completely confused and jokingly responded, "That's not a real dog," before explaining that he only likes big dogs because small dogs are this big and always run away. The courtroom burst into laughter as the woman awkwardly tried to explain why she wanted the puppy so badly. But then, the hearing suddenly became emotional. The woman revealed she originally wanted the dog for her young daughter, who was only 2 years old at the time. She also admitted that someone had recently stolen her daughter's previous Yorkie, which made the situation even more personal and emotional for her family. What started as a funny courtroom exchange about tiny dogs quickly turned into a deeper conversation about poor decisions, emotions, and desperation. Even the judge seemed caught between laughing at the situation and trying to understand why the defendant made such a reckless choice. From hilarious reactions to awkward courtroom laughter to surprisingly emotional testimony, this hearing became one of the strangest and most unforgettable dog theft cases the courtroom had ever seen.